I have sat on this bench long enough to know when routine will hold and when it is about to fail. Over decades, across departments, thousands of officers have stood in this room and learned its limits quickly. Most stand when directed. Most speak only when recognized. Most understand that the court speaks last. That expectation has survived calendars heavier than this one. But on the morning in question, with a full docket and a gallery fuller than it needed to be, routine failed, and the record would later show why it could not survive what followed. The matter was called in the ordinary sequence. The clerk read the docket number. Counsel announced appearance. The defendant was present, seated at counsel table. Before any exchange, the record already established who he was, a sworn law enforcement officer of supervisory rank, more than 15 years of service, assigned to a unit that appeared in this courtroom often. Prior transcripts reflected repeated appearances here on behalf of the state. The authority attached to that role was documented, not inferred. He had operated within this room before. He knew exactly how it functioned. I took the bench and waited. The gallery held more observers than the calendar required. Uniformed officers stood along the rear wall, not assigned, simply present, spaced as if by habit rather than instruction. The marshal took position near the aisle. The clerk prepared to proceed. When the defendant's name was called, counsel rose. The defendant did not. He remained seated, shoulders set back, hands placed deliberately on the table. No instruction had yet been given, but the choice was visible. The record moved forward anyway. The clerk paused, waiting for him to rise. He did not. The pause resolved itself without correction, and the gallery noticed. The choice not to stand was visible, deliberate, and understood by everyone who noticed it. Counsel announced readiness. The clerk paused, waiting for the defendant to rise. He did not. The pause ended when the clerk continued reading. The irregularity was small, but it shifted alignment. The room adjusted before the court did. The clerk proceeded without acknowledgement, and the gallery noticed the pause resolve itself without correction. I did not intervene. The record absorbed it. The issue before the court that morning was narrow and immediate, a compliance determination tied to a pending motion that carried the possibility of custodial enforcement if the existing order was not obeyed. That authority was already on the record. It required no explanation. As counsel began, the defendant leaned back further and spoke without recognition, addressing neither the court nor his counsel. The words were brief and out of turn. The clerk stopped mid-sentence. I waited. No correction was made. Counsel attempted to continue. The defendant spoke again, louder, still seated. The interruption was a choice, not confusion. He had been here often enough to know the order of address. I allowed counsel to finish the sentence before directing the clerk to note the interruption. The record reflected it. The defendant then stood, not when instructed, but when he decided to. He turned partially toward the gallery rather than the bench. The movement mattered. Heads in the gallery shifted toward him. I did not respond. I consulted the docket and instructed the clerk to read the relevant order into the record. The reading proceeded. The defendant remained standing, facing away. The distance between him and the bench narrowed by a step, and the marshal adjusted his stance to maintain the aisle. When the reading concluded, I cited the rule governing compliance and asked counsel whether any lawful basis had been presented that morning for deviation. Counsel answered. The defendant interrupted again, this time directing his statement toward me. He spoke clearly, audibly, and on the record. This court is a joke. The rupture did not announce itself with noise. It announced itself by freezing the room in place. The clerk did not move. The gallery stopped shifting. The marshal's posture changed. Wait forward. I waited, allowing the silence to remain long enough for alignment to change. Attention moved from counsel to the bench, and the statement settled into the record as something that could not be withdrawn. I restated the rule and issued a direct instruction to be seated. The defendant did not comply. I repeated the instruction and directed that the statement be noted verbatim. At that moment, return was no longer possible. The chain was complete and visible. Conduct observed, rule cited, order issued, non-compliance recorded. I deferred immediate action and placed the matter in recess. directing the marshal to maintain position and the clerk to secure the record. The case did not conclude that morning. The authority of the court was not argued. It was scheduled. The recess ended on the record. The clerk announced the resumption. The gallery remained full, but the spacing at the rear wall had changed. The officers stood closer together, now no longer casual. The defendant returned to counsel table without instruction and remained standing. Counsel rose. I reviewed the docket aloud, confirming the pending motion and the court's authority to enforce compliance that day. The scope was narrow. It was sufficient. I asked counsel whether there was any correction or clarification requested regarding the statement made before recess. Counsel responded that there was not. The defendant interjected before counsel finished, asserting that the court was overstepping and mishandling the matter. He did not repeat the earlier phrase. He did not need to. The record already held it. I instructed the defendant to be seated. He remained standing. The refusal was deliberate, and the gallery understood it as such. I cited the rule governing decorum and directed compliance. The instruction was simple. The defendant looked at counsel. Counsel did not respond. The defendant addressed me directly, questioning the authority to issue the instruction. He spoke over the clerk. As the clerk attempted to note the exchange, I paused until the clerk stopped, then instructed the clerk to continue. The pause mattered. The clerk resumed without acknowledgement of the defendant, and the defendant raised his voice. I asked the marshal to step forward and stand by. The marshal complied, positioning just behind the defendant's chair. The shift was visible to the gallery. The defendant noticed and turned partially toward the marshal while continuing to address the court. I repeated the instruction to be seated. He did not comply. Another threshold passed. The motion was addressed. Counsel argued compliance through alternative means. I asked for a filing to support it. The clerk searched. None was found. The defendant interrupted, stating the filing existed and that the court had failed to review it. The clerk confirmed it was not present. The denial of the requested continuance followed immediately. It was procedural. It removed the last delay. The defendant stepped into the aisle between counsel table and the bench, closing distance again. I instructed him to return. He did not. I directed the marshal to issue the instruction. The marshal did. The defendant refused. The marshal repeated it. The refusal was audible. The gallery did not move. I cited the authority to maintain order and instructed the defendant by name to comply immediately. He responded that the proceeding was illegitimate and that the court had lost credibility. I instructed the clerk to read back the earlier line, "This court is a joke," and confirm its inclusion. The clerk did. The record closed around it. I informed the defendant that continued non-compliance would result in enforcement of the court's authority. I did not describe how. I asked once more for compliance. He remained where he was, closer to the bench than before. His voice increased. The statement shifted from procedure to challenge. Counsel remained silent. The failure to intervene was noted by its absence. I allowed the defendant to finish speaking. When he stopped, I waited. The silence that followed shifted responsibility entirely onto him. I then announced that the court would proceed with enforcement of the existing order and directed the clerk to mark the conduct accordingly. I ordered a brief procedural pause to allow the marshal to confer with supervisory personnel. The pause was placed on the record. The defendant attempted to speak during it. I did not acknowledge the attempt. Before leaving the bench, I stated that the earlier statement would be formally addressed in the court's next action. I did not specify how. The officers at the rear wall closed the distance to the aisle. The authority at issue was no longer abstract. It had position. The pause ended without resolution. The next step was set, not explained. The court returned to the record without announcement beyond the clerk's voice. The pause had changed the room. The officers along the rear wall no longer stood as observers. They stood as a line, visible from every seat in the gallery. The defendant remained between counsel table and the bench where he had placed himself. Counsel stood beside the table. I confirmed the procedural posture aloud. The court was addressing compliance with an existing order and conduct occurring in open session. The authority to act existed at that moment. Nothing further was required to establish it. I asked counsel once whether the defendant intended to comply with the court's instruction to be seated so the proceeding could continue. Counsel turned toward the defendant. The defendant did not answer. Counsel. He addressed the court instead, stating that no compliance would occur until the matter was transferred. He cited no rule. He filed nothing. The refusal was framed as a condition, not a misunderstanding. The gallery heard it. I repeated the instructions, citing the rule governing immediate compliance with lawful orders of the court. The defendant spoke over the citation, stating that the court could not enforce it against him. He took a step forward. The distance narrowed again. The marshal shifted to remain directly behind him, making the line of authority visible to the gallery. That shift mattered. Conversations in the back row stopped. The misjudgment was no longer procedural. It was physical. The defendant raised his voice and spoke faster, interrupting both the clerk and counsel. Each interruption was marked with time and sequence. I did not correct him verbally. I instructed the clerk to continue noting the record. The lengthening of the transcript became its own response. I made a limited ruling denying any transfer or delay on the ground that no motion supported it and that the court would proceed. The ruling was immediate and final. It removed the last procedural shelter available. The defendant responded by stating that the ruling had no effect on him. He gestured toward the gallery and described the process as meaningless. The words were dismissive, and they landed as such. A threshold had been crossed. The court could not retreat without surrendering control. I instructed the marshal to issue a final directive to comply. The marshal did so clearly and without emphasis. The defendant turned partially toward the marshal and stated that no order from the bench would be followed. The exchange was brief. The marshal did not reply. He waited. That waiting mattered. It placed responsibility back onto the defendant, where it would remain. I cited the authority for enforcement allowed and ordered that the defendant be taken into custody if he failed to comply immediately. The order was clear and conditional. The defendant responded by laughing once and stating again that the court was a joke. The phrase matched the earlier line exactly. The clerk noted it. The repetition removed any remaining ambiguity about intent or awareness. There was no return from that moment. I waited. The silence that followed altered the room. The gallery did not move. The officers along the wall shifted their footing in unison. The marshal placed a hand on the defendant's arm and instructed him to turn and place his hands behind his back. The instruction was audible. The defendant resisted by pulling his arm away and stepping toward the aisle. Two officers moved forward from the rear wall to assist. Their movement was visible to everyone present and marked the transition from warning to action. The physical positioning changed again. The marshal repeated the instruction. The defendant continued to speak while resisting. He did not comply. The officers applied restraints in a controlled manner. The process was deliberate and public. The defendant's voice rose, then cut off as the restraints were secured. The silence that followed was different from before. It signaled that the court's authority was no longer being tested. I placed the next statement on the record, that the defendant's repeated refusal to comply with lawful orders, combined with the statement "this court is a joke," constituted grounds for immediate custodial enforcement under the cited rule. The clerk recorded it without pause. The causality was intact and visible. The defendant was escorted toward the exit. He continued to speak as he was moved. I did not respond. I instructed the clerk to mark the time and suspend further proceedings in the matter pending formal review. The escort passed through the gallery. Officers opened the doors. The sound of the doors closing registered as the last movement in the room. I addressed counsel and stated that the underlying compliance matter would proceed separately and that the defendant's status would be addressed through institutional channels. I did not elaborate. The marshal returned to position. The officers at the rear wall remained where they were until the defendant was no longer present. The authority in the room had shifted fully, not by declaration, but by action. The defendant was gone. The proceeding remained. I ordered the matter continued and placed the next procedural step on the record without setting a date. The unresolved question was no longer whether the court could act, it was how the institution would respond next.